Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of the Probate Realtor Show. Today, we are talking to Omid Afati. Omid, welcome to the show.
Thank you, Matias. I appreciate you inviting me over.
Absolutely. So Omid practices in the area of estate planning and trust and estate litigation, and he is with Shoop Legal. Omid, I want to get right on this on the subject matter. One of the things that I wanted to talk to you about is how your litigation practice has informed your estate planning, because you get to litigate, somebody's bad estate planning, I should say. I don't know if I could be as bold as saying that, but let me just clarify the question so that you kind of understand like exactly where I want to go. What are some of the is a lot of the litigation due to ambiguity in the estate plan, or what are some of the most common things that lead to litigation? Let's go from there.
Sure. So I'll give you just a little background. I've been doing trust and estates law for a little under a decade now.
Nice.
Right now, my practice is more focused on estate planning, but before this, I spent years doing trust and estate litigation. So I've read hundreds of trust documents. Either it's one of those ones you download online, or some attorney had prepared it and there were issues with it. I'll tell you, the number one issue is really about ambiguity. What did the settlors or the trustors want to happen? And if language is not clear in the documents, then usually that issue has to end up in courts and for a judge to decide what did they really intend. And so that was the biggest problem, was clarifying what your wishes want. I can tell you a number of horror stories related to that.
Oh, I do. I want to hear it. Definitely. Please share the horror stories.
Yeah, I'll tell you, for example, I've dealt with a lot of cases that ended up going to trial. One issue was about what did the mother intend? And the language was not clear. The issue was really about, did they want, $100,000 to be split equally amongst 5 grandchildren, or did they want $100,000 each to go to each child, to each grandchild? And that's a big difference. That's a $400,000 difference. And that issue ended up going to court. We ended up being in court for 2 years, 3 years, that kind of thing. And it was a long time. And then thankfully, we were able to settle it before we got into the trial with the judge. But that's just one of the many issues, is that it's not clear what the language is. It's ambiguous, or there's questions. One person thinks it reads this way, another person reads it a different way, and the only way to resolve it is going to court.
I mean, there are debates on the meaning of language that have been going on in this country since 1776. What is the Second Amendment? Where's the comma? Is in the right place? So now that you have that experience, your experience in litigating, your experience in, I don't want to be, so bold as to say dealing with bad estate planning, but essentially that's what you're doing. Now that you're doing the estate planning, how has that changed the way you approach estate planning? In a sense, are you like taking specific strategies? Are you looking at the language and being like, well, if we put that in here, to the client, they can think you mean this or you mean this. So we need to kind of like, so walk me through the process a little bit, please.
Yeah, absolutely. So, my experience, because I've read hundreds of estate plans done by other attorneys, my whole goal when I was reading those documents was, where are the mistakes? Where are the ambiguities? Where are the holes? And then I would exploit them to benefit my client, so to speak. Now that I've done that, I know where the common mistakes are. I know what would help prevent fighting in the future. And I know how to make sure that if this ended up in court, how do we defend the position of the person who prepared the document? And so I bring all that information with me into my practice. For example, again, a lot of this has to do with intentions. What did they intend to happen? And so it's really important for me when I meet with my client is that I take extensive notes. I take a note on who this person is, who are their relationships with other people, like their children. Is it good relationships? Is there contention in between them? How's their relationship with their spouse? I take notes on all these things because I want to know how their wishes are being met with their relationships with the people they want to leave things to. So these are all really, really important issues to kind of cover right in the beginning when I meet with my clients. And then after that, we go into the process of preparing their documents. And I'll tell you, our firm, we do a 4-step process. Every step of the way, we are confirming their intentions. Is this what you want? Are you sure about that? Do you have any questions or concerns about what we're about to sign? It's very important to have those clear intentions known to the attorney so that we can prepare a good, comprehensive estate plan.
That makes total sense. Thank you. Thank you for elucidating on that point, which kind of leads me to the fact you are guiding the person to make sure, somebody may come to you and say, how do I make my wishes known? How do I make sure that my wishes are clear? And I guess you could tell them, hey, here's the pitfall if you go this way, here are the pitfall if you go the other way. Let's talk about the process specifically. One of the things you said that I think it's very important is that you take a lot of notes. So you meet with the people and you take a lot of notes. Now, we know that an estate plan, it's a kind of like a holder for a lot of documents, like medical care directive, et cetera, et cetera. If there are minor children involved, you're nominating a guardian and all of those things. My question to you is, there's so many aspects to it. There's a lot of things. People could get overwhelmed. People could be like, I don't know. How are you and the firm helping them sort of figure that out? Because when I come to you, I may think I'm only thinking about what's happening to my house when I die. That's all I'm thinking. And now you tell me I got to decide who's going to take care of me if I'm in a coma and who's going to take care of my kids. And I'm thinking like, I wasn't expecting this. So tell me, how does your firm and what is your strategy to kind of let people, develop trust in you and kind of like put everything on paper, I guess?
Yeah. So, a client will schedule a meeting with me to speak with me about preparing an estate plan. And then in that meeting, I kind of go through all those issues with them. So I kind of explain to them what an estate plan is. It's usually comprised of 4 primary documents: the trust document, the will, the power of attorney, and the advanced healthcare directive. And I explained to them during that meeting what each one of them are and how they're very valuable and important depending on certain life circumstances. And so we go through all that during that first meeting. We don't go into the nitty-gritties yet because we want to make sure that first, if there's something that you want, then we can kind of go through our process from there. But we really get into it during our second meeting. That second meeting, we go into the nitty-gritty. We try to go through all the meats and potatoes. So I explained to them, when you're picking someone, for example, to make financial decisions for you, you want to make sure you trust them and that you have confidence in them. A lot of times, people don't know who to pick. Do I put my spouse? Do I put my kids? And we'll go through those options together. Again, from that first meeting, I already know a basic understanding of their relationship with the people around them. And so I can kind of guide them in a sense to say, this person is going to have access to your money in your bank account. Comfortable with that. This person can pick up your mail at the post office. This person can get a loan out in your name. Are you comfortable with these situations with this person doing that for you? And so I make sure that they understand the consequences and the benefits of picking people for certain positions, and that at least this way they can make an informed decisions. I'll tell you, I can never tell somebody what to do. All I can do is kind of advise them on the pros and cons of what they want to do, and then ultimately they have to make their own decision. Yeah,
I think in that sense, like us who are professionals kind of like selling, services, we have learned over the years that telling people what they should do never goes well. So you kind of have to you provide the information and then they can make their own decisions and you can say, look, these are the pitfalls if you decide this way. These are the pitfalls if you decide the other way. So yeah, I can sympathize with that.
That's right. My goal as an attorney is to make sure my client is informed before they make a decision. I don't want them to make a decision that they don't understand or they're not fully aware of. And so I want to make sure I give them the best explanation possible so that they can make a decision that's best suited for them.
Got it. Now you brought something back. You brought something up in your answer, which I think is very important for us to kind of expand on. You said, when you pick somebody to make financial decisions for you, you want to pick, somebody that is, that is trustworthy. So my question to you, one of the issues that we discuss on this show is elder financial abuse and how it can lead to terrible results. So when you are assisting people in making the decision, I guess the first thing that I wanted to ask you is, when do you think it's a good time to bring a neutral third party?
What do you mean by bringing a neutral third
You
party?
know, like sometimes, you know, people want to hire a fiduciary. Like I say, you know, I don't trust anybody with my money, so I'm gonna put, you know, somebody that, or I could say, no, would you be responsible for my finance? I know you cannot do that, but you know what I'm saying? It's like, how would how would you help somebody who basically doesn't have anybody? They think like, look, I don't have anybody that I can trust.
Yeah.
What are my options in that case?
Yeah, so that does happen more often than not. I'll tell you when we meet with people and then they tell us they don't have anybody they trust, whether it be, they don't have any family members or maybe they just don't like their family members.
Right.
When would be a good time to appoint a professional fiduciary?
Hmm.
In that meeting, when I find that information out, then I would normally advise them, we can find a professional fiduciary for you. These are people who are licensed, they do this for a living, and they're highly qualified to make sure they're doing the right thing there. The good thing about a professional fiduciary is that they're independent. They're not
Hmm.
related to you. They don't have any emotional ties to you or to any of their family members. So
Right.
their goal is going to be follow your wishes, whatever they may be. If you want to disinherit a loved one, they're going to make sure that that person
Right.
doesn't get anything. If they want to make sure, if they want to have money managed for a loved one, like if you have a spouse or a child that's disabled
Hmm.
and they can't manage the money themselves, a professional fiduciary will make sure that the rules are being followed in accordance
Right.
with your wishes. And so we would recommend it, but it would only be under certain circumstances. I'll tell you from my practice, I
Hmm.
like having families being involved in the process. So I do
Hmm.
encourage people that I meet with to appoint family members that they trust because there is that emotional tie and they
Right.
care to help. Professional producers are just going to follow your rules, which is not bad. It's good sometimes, but oftentimes I would prefer a family member.
I understand. That makes sense. And I agree with you. Obviously, you know, if you have somebody you can trust, etc., just, you know, that is within your family, that's always the best choice. I wanted to, you know, one of the things that essentially estate planning does, you know, and as we talk about, it's, you know, prevent keeping people out of probate court, right? Don't go do an estate plan so that the state doesn't get to decide what the plan is when you pass away. One of the questions that I wanted to ask you in that regard is when people do estate planning, sometimes like shoddy estate planning, I should say. They don't fund the trust, or they take something out and don't put it back in. How do you make sure that you keep your client out of probate court by making sure that they've made the right steps so that they don't go in probate, like funding the trust and things like that? How are you helping them? And what happens if they refinance and take the property out? Do you check in regularly? How does that work?
Yeah, great question. So that is a issue that we deal with a lot in the probate world is funding a trust.
Mhm.
Our practice at Shoop Legal, what we do is we help them fund their trust from the beginning. And
Mhm.
so we're there during the process where we're explaining to them what funding is, why it's so important, because if the asset's not in the trust, it does end up in probate. And so we want to avoid going to probate court. Well,
Right.
our office, we always help out the families any which way we can. And so we help them fund their trust, either be moving their house into their trust or assisting them in moving their bank accounts in their
Mhm.
trust. Now, our firm, we offer different levels of services. So we can help them do it themselves or we can do it for them. But we go through all that process with them during our strategy session with the client. And so that's what we do at our firm. Now, other firms may not do this, like you mentioned before. Sometimes they want to refinance, and part of that process is taking the house out of the trust. What we do at Shoop Legal, we give instructions to our clients. So we provide
Mhm.
them with written instructions for in the event you do refinance, or maybe you bought a second house, or maybe you open a new bank account. How do I move it into my trust? How do I fund my trust with that asset?
Right.
But we do provide the client with instructions on how to do that. Oftentimes, they don't do it themselves, or they just don't want to read the instructions. And so, they'll contact us,
Mhm.
they'll inform us, I've got to refinance. I think my house is not in my trust. Can you help me? And then we'll go through the process of meeting with them and discovering whether or not that is the case. Um, I'll tell you a lot of times when people don't fund their trust and then they pass away, the issue does end up in probate court. It can move slowly or it can move fast depending on the family members. Some family members are okay with it, and so you get agreement from everybody and it can move faster. Oftentimes, more often than not, somebody wants to contest it to say, no, that wasn't intended to be in there. And so
Mhm.
it turns into a battle. But the best way to avoid it is to do all the funding up front, right when you create
Right.
your document so that you don't have to run into this issue later. And of course, if you discover that, hey, I had to pull my house out, definitely contact an attorney. They will be able to help you before it becomes too late.
Got it. Now, life happens. Okay. So somebody comes to you with a perfect plan, and then they get divorced. There's mixed family, blended family, there's death. I mean, all sorts of things.
Yes.
How do you explain to your client when is the time to reach back out to you? What life changes is it appropriate to reach out and revise the plan?
A great question. So we always advise our clients to have your documents reviewed at least once every 5 years.
Okay.
Just a review. Attorney's going to look at it. What I do with my practice is I read the documents to them. So I say, look, this is who you appointed as your successor. Is this still who you want?
Right.
This is what you're giving to this person. Do you still want that gift to be made? And I'll go through that whole process with them just to confirm their intentions. Again, all comes back to their intentions.
Right.
If their intentions have changed, then we'll go through that process with them about how to make changes to their document. But other than the 5 years, what I advise is if there's a major life event, definitely go talk to an attorney about your estate plan to make sure your wishes are still being met. A major life event could be a divorce. It could be a death of a child or the birth of a new child.
Right.
It could be even the straining of a relationship. If you're no longer talking to your children, or your friend, you got into a fight with your friend that you had appointed as your successor and you haven't talked to him in years, these are things that you need to let us know about. If it's something that's within the body of the trust, whether it be your successor or your beneficiaries, and an issue has changed where now your wishes are no longer the same, definitely go meet with an attorney, definitely have your documents reviewed so that we can correct those mistakes that are now mistakes, essentially.
That makes sense. So you're recommending basically at minimum every 5 years, like do a little checkup to make sure everything is still in order.
Exactly. Like, they always recommend have your physical done once a year. We recommend have your estate plan physical done once every 5 years.
Yeah, that makes perfect sense. Let's talk about this transition that we chat about at the beginning of our show, which is your transition from litigation to estate planning. I talk to a lot of former litigators, and I talk to people that do litigation just full time. What happened? What was the transition like, and why did you feel it was necessary to make it happen?
Yeah, so I did the litigation for a long time. I did it for like 5 years before I became a estate planner. And, I went into it because I love the probate law. I love the idea of inheritance and things passing to family. I'm very close with my family, and so I want to help other families in that sense as well. And so I helped a lot of families, but litigation being the beast that it is, you're dealing with problems that occurred and now you're trying to fix the problems now. And so, it has its tolls on stress and stuff like that. It was very rewarding, but, it's a lot of work to get to that point. And I'm realizing as I'm doing this, the main reason why I'm in court right now, the main reason why these people are fighting is because somebody had prepared poor documents, shoddy documents, as you mentioned before. And so, this is really the core issue here, is that these documents are not being prepared properly. These families are meeting with either attorneys or they're printing something out online, and they're, thinking that's okay. Like what they've done is going to be sufficient for when they pass. And so I'm realizing, the main problem is here. Like, this is the core issue. And how can I help families avoid going to court? And so I made that transition over to estate planning, where now I'm helping families prepare their estate planning documents. And, knock on wood, none of my estate plans have ended up, litigated. Everything has been moving smoothly with the ones that I've prepared so far. But essentially, my goal here has been to help these families prepare the proper estate plan so that their families never end up having to hire me to litigate the issues for them.
That makes sense. Thank you for explaining that. Let's pivot a little bit. Let's talk about your journey this is a question that I love to ask. When you were a kid, did you want to be an attorney?
Great question. Not really, no. I didn't grow up with the aspirations of becoming an attorney. I'll tell you, I've always been someone who believes in right and wrong, good and evil in a sense. And I've always been one to be influenced by good. I want to do good. I want to help other people. And what was the best way to do that? And plus, growing up, I used to argue a lot with my friends, with my family. They always told me, you should be an attorney. You should be an attorney. And so, that was always kind of in the back of my mind, but it was never my main goal and aspirations. I'll tell you a funny story. Actually, it was after I graduated from college, I was debating whether to go to law school or to study abroad in China. I was studying a
Oh,
China
wow.
undergrad, yes. And so the issue was, which path do I take? Do I go through law school, or do I go to China and really focus on learning the language? And I'll be honest with you, I was having conversations with my family about it. And ultimately, it was like after hours of conversation, which way to go, I ended up flipping a coin on it, saying,
Oh, wow.
heads, I'll go this way, tails, I'll go that way. And, fortunately enough, it ended up being law school. And so we went that route.
That's interesting. Thank you for sharing that. Let me ask you a question about your time in law school. I know that you get to practice. A lot of people that go to law school, at least it's been in my experience as I talk to them. Like everybody's like, I'm gonna be in criminal, defense or like they want to do the what they see on the TV shows, right?
Yeah.
There's no TV shows about estate planning attorneys, not yet. We should have one. Yeah, let me ask you, when you took the class, on trust and wills and et cetera, were you like, oh, this is it, this is what I'm going to do, or were you like, I don't know, like how did it happen essentially that you went into that area of practice?
Yeah, so I'll tell you, that's a great question. It wasn't law school that made me want to do trust and estates.
Okay.
The trust and estate class that I had was more about like language, about specific way of wording things, and it wasn't really all that interesting, to be
Uh-huh.
honest. The passion for it really came in my first year of practice. I was working
Mhm.
at a small boutique firm, and one of the first cases I had was a trust and estate case where it was an issue related to a trustee who had sold a property that was in the trust to themselves. It was
Mhm.
considered self-dealing. And so we were litigating the issue. I was representing the beneficiaries of that trust. It was three daughters, if I remember correctly, or two daughters. It was the children of the person who passed. And then, their family friend, who was the trustee, sold this property to themselves for less than fair market value. And so something
Oh,
inside me just got angry, like, how dare this non-family member steal from the family? And so that really drove my passion to really want to get a good result for my clients. And we ended up getting a very good result for the clients. But that was just the start of it. And then from there, I took on all the trust and estate litigation cases. And then I really focused only on that. I didn't want to do anything else but trust and estate litigation.
that is awesome. And I have my passion in this area of real estate. It's very, very similar to your story. It's about, the fact that you see somebody being taken advantage and you're like, wait a minute, that house is worth way more than what it's like,
Yeah.
because when people go through probate, it's a lot of the times, if they have limited authority, it's confirmed in court, so you can see what price is being confirmed, and you're thinking, wait a minute, there's something fishy going on over here.
Yeah.
So yeah, that's interesting that was the driving force that got you there, basically to stand up for the little guy or the person that are taken advantage of. I love that.
I'm very close with my family, very, very close with
Uh-huh.
everyone. We have a large family in my family, and the idea of somebody taking advantage of a loved one, it makes me angry. I don't like
Right.
it. And so
Yeah.
when I saw it happen to somebody else, I wanted to help them. I felt that drive to help them.
That makes total sense. And thank you for sharing that sentiment with us. Let's talk a little bit about your firm. What made you decide to join the firm, or is this the first? Did you go out of law school to this firm, or how was the transition?
Yeah, so I moved. I worked at probably two or three law firms before I came here. I
Mhm.
stayed at a few of them for a couple of years. But this firm really kind of piqued my interest. One, because it was focusing on estate planning, and that's where I wanted to kind of pivot my
Right.
career towards. But what really stood out with this firm was kind of the interview process that I had to go through. It was
Mhm.
much more rigorous and much more demanding than other law firms. And my first reaction was like, what are they doing? All these interviews. Look at my resume. That should be enough for you. But afterwards, I started working there. I realized why they had such a high standard for employees working there is because they have a high bar for themselves. The firm
Mhm.
wants to be the top estate planning firm in California, and they make sure whoever they're bringing in is one of the top quality attorneys or top quality paralegals and other office members. And so that rigorous kind of interviewing process showed me once I got inside, oh, this is a very valuable firm. Like they really care not just about their clients, but about their employees as well.
Mhm.
And so that kind of setting that high standard really made it more attractive. And I can see what value that's bringing by having such a high standard working at this firm. And I'll tell you, I've been with this firm for about 1.5 years now, about 1 year and 8 months to be more specific. And Andrea Shoup does a wonderful job of running this firm. She is a machine when it comes to running an estate planning firm, helping families with their estate plans. I couldn't have asked for a better employer, honestly. She's phenomenal.
That's awesome. Thank you. Thank you for sharing that with us. Before I let you go, one more thing. I want to, we're going to have your contact information in the show notes, but what is the best, can you tell our audience, what is the best way to get a hold of you?
Yeah, so just contacting our office. You can go to shouplegal.com. You can call us. Our number is 951-445-4114. If you're somebody that is planning on getting an estate plan done, or you know someone that had an estate plan done and now you need help administering it, definitely call us. We can help you. Anything related to inheritance law, we can help you with.
Wonderful. Thank you so much.
Yeah,
Omid, it's been such a pleasure to have you on the show. Thank you for sharing your wisdom with my audience.
Of course. Thank you for inviting me. It was been a pleasure being on here, and I hope to see you again soon.
Yeah, absolutely. Thank you, everybody, for joining us, and we will see you in the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020544763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.